1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်1131 State Commercial Bank Plaintiff vs THIBAW Commercial Syndicate Limited and 1 Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular Suit before Uttarphe Judge State Commercial Bank Plaintiff vs THIBAW Commercial Syndicate Limited and 1 Respondent Union Judiciary Act Section 15 Cause of Action not arising wholly within the local jurisdiction of the court leave to sue the very foundation for exercise of jurisdiction leave to sue whether a formal matter of procedure suit based on contract held under Section 15 of the Union Judiciary Act where the cause of action has not arisen wholly within the local jurisdiction of this court, leave to sue is the very foundation for the exercise of jurisdiction by this court. It is not a formal matter of procedure which can be overlooked. Rampa Lab, Samrut Rai and another versus Bransuk Tanda Mill and others ILR 15 Bombay 93 refer to Bipin Bihari Law versus Mohit Kumar Bill and others AIR 1942 Calcutta 496 refer to in a suit based on contract, the cause of action consists not only of the making of the contract, but also of its breach at the place where it is to be performed. The contract of guarantee was admittedly executed by defendant number 2 at Mandalay, and its breach took place in Rangoon when they refused to pay the amount for which he stood as guarantor. Since the plaintiff cause of action does not wholly arise in Rangoon, his suit cannot be entertained without prior leave of the court. Muhammad Kali Khan and others versus Mabad Ali Mian and others AIR 1949 PC 78 Bini Madad Sikta and another versus Sarat Chandra Jana AIR 1937 Calcutta 643 Guardian Assurance Company Limited versus Taka Shiva Mangas Singh AIR 1937 Allahabad 208 Mahomet Hali Hamad versus Judy and Kenny Brokers Limited AIR 1932 Bombay 42 The Jupiter General Insurance Company Limited versus Abdul Aziz 1 Rangoon 231 refer to Briju Pandi versus Gangu Ahir AIR 1939 Patna 294 Mr. C.A. Soma for the plaintiff, Uthon Tin for the defendant number 1, Utan Ang for defendant number 2, Uttarphe Judge. On the 26th August 1959, the defendant number 1, THIBAW Commercial Syndicate Limited, opened a letter of credit with the plaintiff State Commercial Bank to import menthol making machine which arrived in Rangoon sometime in November 1959. The defendant number 1 was then short of cash and was unable to make payment for the goods. The plaintiff thereupon made arrangements with Messrs. McKinnon, Mackenzie and Company Limited to clear the machines and paid Jet 22,839.75 to the collector of custom as custom duty. The machines were however confiscated by the custom authorities on failure to pay the penalty of Jet 99,000 imposed as a result of overvaluation. It appeared that on the 10th March 1961, the defendant number 2, Wu Sei-win, stood surety for the defendant number 1 and executed a letter of guarantee at Mandalay for a sum of Jet 150,000 in favor of the plaintiff. The plaintiff thereafter asked for payment of the bills in respect of the imported goods, but none of the defendants complied with his request, hence the present suit. The defendants resisted the suit on various grounds. One of the pleas cited by defendant number 2 was that the suit, having been filed without the leave of the court, could not be entertained inasmuch as the entire cause of action did not arise in Rangoon. It is in respect of this plea, which has crystallized as issue number 5, that the present order has to be made. Section 15 of the Union Judiciary Act, so far as it is relevant for the present purpose, reads: the High Court, in the exercise of its ordinary original civil jurisdiction, shall have power to receive, try, and determine suits of every description, if, in the case of suit for land or other immovable property, such land or property shall be saturated, or in all other cases, if the cause of action shall have arisen either wholly or, in case the leave of the High Court shall have been first obtained, in part within the local limits of the ordinary original civil jurisdiction of the High Court. The moot point that has to be decided is whether the cause of action in the present suit has arisen wholly or partly within the local limits of the ordinary civil jurisdiction of this court. If the cause of action arose partly outside the territorial jurisdiction of this court, the plaintiff must first obtain leave of the court, failing which the suit could not be entertained by this court. Under Section 15 of the Union Judiciary Act, where the cause of action has not arisen wholly within the local jurisdiction of this court, leave to sue is the very foundation for the exercise of jurisdiction by this court. It is not a formal matter of procedure which can be overlooked. Thus, in Rambadep, Samrut Rai and another versus Bransuk Chanda Mill and others 1, it has been held that in suit for which leave to sue under Clause 12 of the Letters Patent of Bombay High Court, which correspond to Section 15 of the Union Judiciary Act, is necessary. The plaintiff cannot afterwards be amended by asking leave to give jurisdiction. See also Bipin Bihari Law versus Mohit Kumar Bill and others 2, where it was ruled that failure to obtain leave under Clause 12 Letters Patent is not a mere irregularity and that the absence of leave goes to the root of the court jurisdiction over the subject matter of the suit. The words cause of action mean every fact which it would be necessary for the plaintiff to prove if traversed in order to support his right to judgment of the court, v.d. Mohammed, Kali Khan and others versus Mabed, Ali Mian and others 3. In Bini Madhab, Sikta and another versus Sarat Chandra Jana 4. The definition of causal action has been given thus: a cause of action consists of the entire set of facts which give rise to a claim. It includes everything which, if not proved, give the defendant an immediate right to judgment. It includes every fact which is material to be proved to entitle the plaintiff to succeed. See also Guardian Assurance Company Limited versus Taka Shiva Mangal Singh 5. Wadia Judge has this to say in Mohammed Haji Hamad versus Judy and Kenny Brokers Limited 6. The words cause of action in Clause 12 letters patent mean every fact essential to the maintenance of the cause of action, and each one of such facts separately is a part of the cause of action. It is settled law that in a suit based on contract, the cause of action consists not only of the making of the contract, but also of its breach at the place where it is to be performed, v.d. the Jupiter General Insurance Company Limited versus Abdul Aziz 7 and Briju Bandi versus Kangu Ahir 8. In the present case, contract of guarantee was admittedly executed by defendant number 2 at Mandalay, and its breach took place in Rangoon when they refused to pay the amount for which he stood as guarantor. The signing of the contract of guarantee and its subsequent breach, if traversed by defendant number 2, would have to be proved by the plaintiff before he can succeed in his suit. The making of the contract of guarantee and its subsequent breach are essential facts for the maintenance of the plaintiff's suit, and each one of such facts separately is a part of the cause of action, which undoubtedly does not arise wholly within the original civil jurisdiction of this code. Since the plaintiff's causal action in the instant case does not wholly arise in Rangoon, his suit cannot be entertained without prior leave of the court. It has been said in the course of argument on behalf of the plaintiff that the suit must be deemed to have been properly instituted inasmuch as U Tenmin, the manager of the plaintiff bank, had stated that defendant number 2 carries on business in Rangoon. It must, however, be pointed out that the plaintiff has not relied upon this ground as the cause of action of his suit. In paragraph 14 of his plaint, he has alleged that the court has jurisdiction to try the suit as the amount under the letter of guarantee is payable in Rangoon. Although the examination of U Tenmin was completed so long ago as 17 November 1965, the plaintiff has not chosen to amend his plaint to base the cause of action on the ground that the defendant is carrying on his business in Rangoon. For this reason, the argument of the learned advocate for the plaintiff on this score cannot be accepted. Under the circumstances, I am of opinion that, since the cause of action in the present suit does not arise wholly within the original civil jurisdiction of this court, the plaintiff suit, which has been instituted without prior leave of the court under Section 15 Union Judiciary Act, must fail so far as the defendant number 2 is concerned. Accordingly, I direct that the suit against defendant number 2 shall stand dismissed with cause.